comply with the relevant legislation, the Interception of Communications Act, is a breach of the Charter. And the reason, quite simply, is the legislature has decided, effectively, the limits of what are justifiable interferences with the right to privacy by imposing a procedure that needs to be gone through before there can be interferences with that right to privacy. And if an individual such as Corporal Brown goes beyond those restrictions, in our submission it becomes clear that it can't be justified, essentially, because as I say, the legislature has set the limits. There's a sort of analogy we draw in our written case between the point my Lord Reid made in the Osborne case about how human rights standards are often in very general terms, and it's for domestic law effectively to fill in the gaps. And that's what we say the Interception of Communications Act does in this case. It is what fills in the gaps in a very general statement about the importance of the right to privacy. And that's why it's so important, compliance with it. And that's why, in our submission, it is comply with the relevant legislation. The Interception of Communications Act is a breach of the Charter, and the reason, quite simply, is the legislature has decided, effectively, the limits of what are justifiable interferences with the right to privacy by imposing a procedure that needs to be gone through before there can be interferences with that right to privacy. And if an individual such as Corporal Brown goes beyond those restrictions, in our submission it becomes clear that it can't be justified, essentially, because as I say, the legislature has set the limits. There's a sort of analogy we draw in our written case between the point my Lord Reid made in the Osborne case about how human rights standards are often in very general terms, and it's for domestic law effectively to fill in the gaps. And that's what we say the Interception of Communications Act does in this case. It is what fills in the gaps in a very general statement about the importance of the right to privacy. And that's why it's so important, compliance with it. And that's why, in our submission, it is the deceased, his girlfriend, or Mr. Chow. All the indications are indicated that it goes beyond that, and that's why these safeguards matter in our submission. Two other provisions worth just noting. Firstly, partly so I can avoid going back to them. Firstly, section 16 is the right to a fair trial by an independent and impartial court. Included within that, in the criminal context, at subsection 6G, is the right not to be tried in your absence. That is obviously relevant when we come to the jury issues. It does have some implications, though, for the first issue, the admissibility, because in our submission, and we've made this clear in our written statement of case, Jamaica is, as far as we can see, the only Caribbean country that has used independence essentially as a way to enhance human rights. And one sees the fact it was intended to enhance human rights in the Joint Select Committee report that led to the Constitution. If you go to 8213, this is the final report. There is a lengthy history, and we've set it out in our written statement of case. I'm not going to take you to it, and we've included the materials about it. There's a lengthy history of debate. It was a particularly long debate process. But the final report of the Parliamentary Joint Select Committee, it helps in two ways. Firstly, it makes it clear at 8213 that the Constitution was influenced by other written constitutions, and that's partly why we submit we're entitled, for example, to refer to the Irish constitution because it is a written constitution with similar features. Clearly, part of the aim of this process was to reflect developments in other states. More importantly, though, in one sense, one of the recommendations of the committee, which was adopted Yes, I mean, obviously that's an important...
Can anyone seek redress for a breach of anybody's constitutional rights?
Well, in our submission, anyone can enforce those rights because of the first point I made, which is about the need...
to do in these proceedings.
Sorry?
And that's what you're seeking to do in these proceedings.
Well, that's what... Yes, because that... Well, it goes back to the Muhammad...
Your constitutional rights that were breached on any view. It's not the rights of Mr. Jones and Mr. St. John. Well, there clearly were issues in relation to one of the defendants, but as constitutional rights, because there was data in relation to one of them. That's Mr. Campbell.
Yes, Mr. Campbell. But the more important point in any event is that what this case law, what Muhammad it recognises is that, and this is made even perhaps more expressly clear by the Irish Supreme Court, is that if the courts simply ignore breaches of constitutional rights, then there is then the problem is that there's no incentive essentially on the state to comply with them, or there's very little incentive on the state to comply with them.
But Muhammad was dealing with a breach of the defendant's constitutional rights.
The jury.
Sorry, no, yes, you're right. He told the jury, but the problem is that in one sense is part of a package. I mean, because what the Court of Appeals say before that, and they expressly rely on this, what he was told before, and certainly the judge doesn't stop the forewoman doing this, is that she was also going to effectively talk at this. What was apparently said by one of the defendants to the juror's son, because she became distressed at that point in time.
Maybe the judge didn't go as far as he should have done in the questioning, but my question relates to where it should have taken place, whether it was in open court or whether it was in the judge's chamber.
Well, there's a strong, I would argue that current practice generally is that there is a strong presumption in favour of it being in front of the defendant so that they can contribute. If there is a particular concern, I accept that you can question in the absence of the defendant, but you have to here, part of the criticism is, in one sense, it just seems to have been assumed it wasn't going to take place. It's not clear what the evidential basis for that or what the reasoning was.
Well, there was a particular problem here which was thought to have emanated from one of the defendants because he'd seen the juror in the prison.
Well, he'd see, what had happened. Yes, but I mean that on its face is not something that's. There isn't a very clear record of how certain key acts were taken, and I'm particularly thinking then, in relation to that, of the role the forewoman then takes in terms of sort of reassuring the jury. And going back to this incident, probably more important than the point I just was making, which was that this was in the absence, is that. If you look at, going back to paragraph 36 of the Court of Appeal's judgment, one of the things that happened was that the forewoman indicated that she would soothe everyone's mind, I think is the language used. That is, in our submission, quite clearly not the same as giving a helpful direction, partly because, it goes back to the point I was just making, there's simply no record of what she does. One doesn't know what she says. One of the reasons why direction is so important in our submission is because it means there is no doubt as to what the jury are being told.